On April 16th, 2024, a panel on the North Carolina Court of Appeals ruled that North Carolina Governor Roy Cooper violated the constitutional rights of certain business owners in North Carolina as a result of the way that he managed the COVID-19 pandemic. This is going to be the first video in a series I'm going to do where I'm going to walk through recent Court of Appeals and Supreme Court decisions and break them down. I'm going to be going over the factual background of these cases, explaining the court's holding and the court's reasoning. My hope is that other lawyers will find these primers helpful in understanding the recent decisions that are coming out of our appellate courts. And I know that many people in the public find this stuff interesting. And I hope that I can sort of give some guidance on how, as a lawyer, I look at and read these decisions. As a personal injury and civil litigation lawyer, a lot of the cases I'm going to look at are going to have to deal with those areas because that's what I'm interested in. But I'm also going to look at cases like this one where they're just factually interesting and I think it's worth exploring and understanding. All right, so let's get into this case. The case is North Carolina Bar and Tavern Association et al. Versus Roy A. Cooper III. Didn't know he was the third. That's cool. In his official capacity as governor of North Carolina. So the plaintiffs in this case are a bunch, and I mean a bunch, like several hundred bar and tavern owners. And the named plaintiff, the North Carolina Bar and Tavern Association, is this industry organization that represents their interests. And they have sued the Governor Cooper, and he's the only defendant, is Governor Cooper, and he's been sued in his official capacity. And for non-lawyers, when we say that someone's being sued in their official capacity, that just means they're being sued as a representative of the state. So this case has its roots back in March of 2020. And as we all remember, that was the very beginning of the COVID-19 pandemic. And Governor Cooper signed Executive Order 118. And that executive order did a whole bunch of stuff. And one of the things it did is it closed down bars and restaurants. That order is not being challenged. There's no question in this case that the governor had the authority under what's called the Emergency Management Act to shut down bars and restaurants in an emergency. What's at issue is Executive Order 141. So this executive order allowed restaurants to reopen, including restaurants that had bars, like an Applebee's. But it required that standalone bars that aren't a part of a restaurant, they had to remain closed. And that's what's being challenged in this case. And so this case is going to turn on whether or not the governor had a solid basis to draw that distinction at the time he made it in May of 2020. So 141 is signed on May 20th, 2020. On May 28th, 2020, the governor holds a press conference. And I went back and I found this press conference and watched it. One of the things he said was that his administration was going to be relying on data and science. And that's a really important phrase. It comes up over and over again, both in the governor's messaging throughout the pandemic, and the court quotes it over and over again in this opinion, data and science. So he explained that his decisions were being made based upon data and science and in conversations he was having with experts. Well, the day after that press conference on May 29th, the North Carolina Bar and Tavern Association sent a public records request to the governor's office. And they asked for records of the data and science that he was referring to and records of these expert consultations he was having. And as far as I can tell, the governor's office did not respond to that request at all, or if they did, they didn't give any of their requested material. So then we get to June 4th of 2020, and the plaintiffs filed this lawsuit against the governor. And one of the things that they asked for was this temporary restraining order or preliminary injunction to prevent the governor from enforcing Executive Order 141. And they didn't. The trial judge denied that motion and let the case proceed, but also let the executive order go into effect. Right after that motion was denied, the governor filed a motion to dismiss the complaint. And then, as far as I can tell, nothing happened with it. It just sort of hung out there. And that's really typical. You have a limited period of time as a defendant in which you can file a motion to dismiss. And so you'll get defendants all the time that as a part of their initial response to the answer and to the initial discovery, they'll include a motion to dismiss on all their grounds for it, but then not notice it for hearing. And so it'll just sort of be hanging out in the case, just unaddressed until the case gets further on down the litigation timeline. So then the opinion gets into sort of the heart of the bar owner's claims. And I've grouped them into three categories. Basically, they say that closing their bars, but allowing other bars to stay open, violates the North Carolina Constitution. That's their first broad claim that I would say. The second is that they are entitled to be compensated for having their bars closed through the Emergency Management Act. And then the third issue is that they are entitled to attorney's fees because of the governor's failure to respond to their public records request. So we get all the way to October 2021, and the plaintiff files a motion for summary judgment. So the procedural posture here gets a little messy because you've got that original motion to dismiss from the governor that's still out there, and now you've got this new motion for summary judgment from the plaintiff, and those have different standards of review. And what eventually happens is the trial court dismisses the case, rules against the plaintiffs, but it's not exactly clear what standard the judge was using in making that ruling. The Court of Appeals basically says, in the end, it doesn't really matter because the trial court reviewed matters outside of the pleadings in making its ruling. And if you do that, then a motion to dismiss, which was the governor's motion, is treated as a motion for summary judgment. And so in the end, you end up with dueling motions, essentially motions for summary judgment. Either party to win would have to show that there's no dispute of genuine material fact, meaning there's no real dispute here. All the facts that are necessary to decide the case are undisputed. And that given those facts, we, the movant, either the governor or the plaintiffs, we get to win under the facts as undisputed. And so both sides, essentially, that's the standard they have to meet. And the court basically said, we're going to find that the governor wins, and so we're going to dismiss the case. So after sort of explaining the procedural posture, the court gets into the substance of the opinions. So the first part of their analysis is this Section A, which is whether or not this is a taking under the Emergency Management Act. So the Emergency Management Act is a North Carolina statute that gives the governor broad discretion to act in an emergency. The part of the statute that's being interpreted here is this section, which provides for compensation if the state has commandeered, seized, taken, condemned, or otherwise used their property in coping with an emergency, and this action was ordered by the governor. So the bars are saying that under that statute, their property was commandeered, seized, taken, condemned, or otherwise used in coping with this emergency, and that was ordered by the governor, and therefore they are entitled to compensation. So the main question that the court focuses on here is, what does it mean to take? And the lawyers and the law students watching this, when we hear the word taking in this context, we immediately start thinking about the United States Constitution takings clause, which prohibits the government from taking property without appropriate compensation. And there is a ton of case law about what that type of taking is, how it's defined. There is no case law about how to interpret a taking under the Emergency Management Act. And the court concludes that the General Assembly, when they wrote the Emergency Management Act, intended for the word take in this context to be different than take as it's understood in interpreting the Constitution. You know, one of the things that they point out is that the Emergency Management Act gives a whole bunch of powers to the governor that is not accompanied by a requirement for compensation. So they give the example that the governor's empowered to order an evacuation. So if you have a hurricane, you can order an evacuation. And that would necessarily require the closure of businesses. But the statute doesn't give any right of those businesses to any compensation. Likewise, and I think this is the stronger argument, the statute specifically authorizes the governor to prohibit and restrict the operation of businesses in an emergency. And likewise, it doesn't give any provision for any compensation. Now, the counter to that, I think what the plaintiffs say would be, yeah, they didn't say specifically right after closed businesses you get compensation, but it did say that we get compensation if you take our property. And so the General Assembly did say that we get compensation under these conditions. The court says no, that the taking provision in the Emergency Management Act, that's talking about like physically seizing property. If you look at these other words that are listed here, you know, it's commandeered, it's seized, condemned, or otherwise use the property, right? That all sort of connotates a government agent who shows up at your property and says, we are going to be using this now. You're a builder and the Department of Transportation says, it's an emergency, we are taking your bulldozer, we're using it. Or you own a field and the Emergency Management Department shows up and they say, we are using this field as our COVID test site. those would be situations in which your property was taken from you to cope with the emergency. And I think the court probably would find that there would be an entitlement to compensation there. But these bars weren't being used as COVID test sites. They were just shut down. And so there's no compensation under the Emergency Management Act. So they next turn to whether or not this is a taking under the North Carolina Constitution. And I'll just tell you, this area of law has always been confusing to me. I think it's confusing to everybody, but I'll admit it's certainly confusing to me. So I'll do my best to explain it. A regulatory taking is where there's some sort of regulation which, even though physical possession of the property hasn't been taken, value from the property has been taken, and therefore the owner is entitled to compensation. If all the value has been completely eliminated from the property by the regulation, that's what's called a categorical regulatory taking. And then you can have what's called a partial regulatory taking. And basically the court found here as well, there's no unconstitutional taking here because of the type of regulation that was being passed and the fact that there was no physical possession of the property. And that's the thing that the court really focused on in all of its taking analysis, was there was no physical occupation of the property by the state, and so no taking. So far, it's all looking really good for the governor, but this is where things start to change. In Section C of the opinion, the court starts to look at what's called the Fruits and Labor Clause of the North Carolina Constitution. And this will be surprising to a lot of people who aren't familiar with the North Carolina Constitution, that we have what's called a Fruits and Labor Clause. And it says this, it says, "We hold it to be self-evident that all persons are created equal, that they are endowed by their Creator with certain inalienable rights, that among these are life, liberty, the enjoyment of the fruits of their own labor, and the pursuit of happiness." And this provision has been interpreted by our courts to basically guarantee the right to earn a lawful living without undue regulation. Court of Appeals gives some examples where regulations have been found to be too burdensome, that they're unconstitutional. So, one example was businesses that were providing or selling male or female companionship were required to obtain a license, and that was found to be unconstitutional as an unreasonable regulation on that right to earn a living. There have been similar decisions for the dry cleaning industry and for the photography industry. All have said that some licensing requirements are unreasonable regulations on these people's right to earn a living. So then the court goes on to explain that this Fruits and Labor Clause of the North Carolina Constitution may apply when the government shuts down an entire industry if the restrictions imposed by the government bear no rational, real, or substantial relation to the public health, morals, order, or safety, or the general welfare. In other words, if the restrictions are arbitrary and unreasonable. And so the question here is going to be, are the restrictions arbitrary and unreasonable? And it's here that I want to remind you what the distinction that's being drawn in this case is. It's not, was shutting down bars in general arbitrary and unreasonable. That's not what's being challenged. What's being challenged was allowing some bars to open, like the bar in Applebee's, but not allowing standalone bars to open. Was that arbitrary and unreasonable? So, given the standard review here, summary judgment, is there a disputed material fact? The court is going to go into a review of the governor's justifications for this decision. So the Court of Appeals says that our careful review of the record does not reveal the existence of any scientific evidence demonstrating plaintiff's bars, as opposed to the bars located in other establishments serving alcohol, posed a heightened risk at the time of Executive Order 141. And that's an important distinction. They're looking at the time Executive Order 141 was issued. So the governor cites a number of things as the basis for this decision. One of the things he cites too is Executive Order 188, which sort of recounts that there's these studies that support this position. And the Court of Appeals basically just dismisses that entirely for really two reasons. One is it says that the executive order is not itself a scientific study, so it doesn't carry any weight. And the second is that it's from January 2021. And the question that they are interested in answering is, what was the rationale in May of 2020? The second thing that the governor cites to are a bunch of news articles. The Washington Post, NPR, and an article out of Louisiana. And they were all talking about sort of how bars present a higher risk for the spread of COVID. But again, it's the same two issues. The first issue is none of those are scientific studies. They're all news articles. And they all post-date the executive order. And so they can't have been the basis for this decision. According to the court, the governor really only points to one study that discusses this issue. Now, there's a footnote where the court says that there are other studies that were presented by the governor, but they sort of deal with COVID-19 generally and don't deal with this specific issue of do bars present a heightened risk. But again, even with the study that the governor cited, it's got those same two issues. The study does not differentiate between the different types of bars, a bar that's in a restaurant versus a bar that's a standalone bar. And again, the study was dated September of 2020, months after the decision was made in May. Now, here's the problem with the court's reasoning, and this is where I maybe get into policy where I shouldn't, but how is the governor supposed to respond to crises like this and make decisions when there is no scientific basis because the crisis is too new? Look, the court is saying all of these studies, all this stuff you're citing to, Governor, that'll happen months after you already made the decision to not allow these bars to reopen. So that can't be the justification that you use for why this decision was made. And fair enough, but in May 2020, the governor is dealing with a crisis that no one in our generation has ever seen before. And he's trying to presumably make the best decision he can in real time with the information he has. And he doesn't have the benefit of those studies. So how is he supposed to make any decisions? Is he just supposed to do nothing in the face of a crisis like that? And the Bar and Tavern Association people might say, yeah, he's supposed to do nothing. If he doesn't have a scientific basis, a good rationale for why to draw this distinction, then he shouldn't draw that distinction. We're talking about a decision that impacts these people's fundamental right to earn a living. And I guess I'm sympathetic to that point. It's a question I have to think more carefully about, and I suspect that question gets down very deep into people's perspectives about the role of government in general. And I guess I should mention, because it's sort of a cloud that hangs over this whole case, North Carolina's judicial elections in our appellate courts are partisan. And so we know that all three judges on this panel were Republican, and of course, Roy Cooper's a Democrat. You're going to have your own opinions about whether or not that played any impact in this decision, but I think it's important to mention it because it's sort of the obvious thing that is being unsaid in this whole discussion. In any case, the governor might have been better off not saying over and over again, we're going to follow the data and the science when the data and the science wasn't there yet. I mean, I believe he was having conversations with advisors and they were trying to make the best decision they could. But I think the court had a real problem with this constant reiteration of we're going to follow data and science. And then the court says, what's your data and science? And the governor says, here's some news articles. Maybe there's more to it that we just didn't see in this case, but I can see why the court took a lot of issue with that. That analysis that we just went through is really the heart of this decision. The court next goes into a discussion of the public records request, and I'll cover that briefly in a moment. And then it closes with a discussion of equal protection. And I want to go there next very briefly, because the analysis is the same as what we just went through. Basically, the North Carolina Constitution has a guarantee of equal protection under the law. And when you're dealing with the right to earn a living, which in North Carolina is a fundamental right, then the government has to have a very, very strong basis for infringing upon that right if it's going to do so. And the court basically says, go see our analysis that we just did under the Fruits and Labor Clause. For those reasons also, we find that the governor violated the Equal Protection Clause. Finally, the court touches on this issue, which is sort of funny to me in the context of these broad constitutional questions, and it's about a public records request. You remember that I told you that the day after the press conference, the plaintiff had submitted a public records request that went unanswered. And under the public records law, if that happens, the plaintiff can be entitled to the attorney's fees that are incurred in enforcing their right to get access to public records, which is what happened here. The problem is that right to attorney's fees is contingent upon the plaintiff initiating mediation over the public records, which never happened here. The plaintiff included in their complaint a request for mediation, but then there was no further action taken. And the Court of Appeal says that's not enough to be entitled to attorney's fees, therefore you don't get them. So that's this case. It's a really interesting decision. It's sort of the continued fallout from the COVID-19 pandemic. The case is going to go back to the trial court for further proceedings, unless, of course, the governor appeals it to the Supreme Court, where I doubt he'll get a more favorable hearing. So we'll see if he does that. I hope this has been helpful or interesting to you. If it is, do me a favor, let me know. This is sort of a trial run that I'm doing of these videos to see if I enjoy doing them and if they're helpful to people. And so if they're helpful to you or you found them interesting, please be sure to leave a comment and let me know to encourage me to keep doing them. And in the meantime, if there's anything else I can do for you, please don't hesitate to reach out.